Name's the network for Tim and for like Laura, because you just got a plural at Brand Yorkshire. Was really to develop a community of tradespeople, experts and kind of suppliers, because the companies we work with are SME trades guys, SME micro trades guys who all need help, who are all not getting paid, who are having payments held up, and so the aim of the network was to try and create this kind of community where they could go and get help, and they could go and get like support. And it was to help in develop and grow the business, train their staff. It was also help them to find kind of funding to meet the cost. A lot of the stuff we do is free because we fund it 100% from the CITB. So if you're CITB registered, one of the things, the CITB like us a lot because we bring companies to them that they would never get to. And so actually we can bring them like the registrations and we draw down the funding as a result. Now I'll talk about some of this, the stuff we've done with some of our clients later on. It's also to help them engage with training providers, so it helps them to provide savings on the costs of training, provide access to our community of experts. We've got another one here today, like Laura's just about to give us another really good stuff on, it's the dispute resolution, and provide access to community suppliers where they'll get discounts, whatever, so we can use the buy and purchase of the group to drive the prices down. What we have is we have an incentive scheme, so if you bring a friend along and join, if you know anybody who you think this would be good for, if they come along and they join, we'll give you 100 quid. We've got loads of flyers somewhere around that if somebody comes along with your name and that, we'll give you 100 quid. So if you join, you pay £400 or to join. You bring in like 4 members, your membership's free. And we think it's a really good offer, and you can go to as many events as you like. Well, what you also get is access to all the videos, the members part of the site. So when Laura stands up in a minute, there'll be a video, you'll get a chance to have a look at it and go, oh my god, that's fantastic. And then approve it, and then it'll be launched onto the site. As well as really what we tend to do, Laura, is we tend to shove a little bit on LinkedIn and stuff, so it helps to sell you a bit as well. Okay. So this is the type of people we work with, who are living in the valley. They know shit flows downhill, and they're living in the valley. And what they've got is they've got the main contractors up here, and site managers. And they've got problems and issues over snagging and timekeeping. Guys on site not claiming extras and variations, or not having an audit trail to say that these are extras and variations. And then on the other side, they've got your site operatives and subcontractors, again problems and issues, not making money on the job because what they've done is they've rocked up at 8 o'clock, they've knocked off at 2, they've taken 120 quid more for the day. It's a 5-day job. They get to the Thursday, they've claimed 4 days, but there's still 2 days worth of work. And it's something that we sort of help them with. We give them processes, procedures. We'll go and do site audits, all this kind of stuff that helps them to improve the site management. And sometimes it can be a bit hard. And I've had loads of conversations like this week about guys on site having to go to the site and having to shave, and the guys want paid to shave. It's like, no. You just no, you've got the work, you do the work for us, we're not going to pay you to shave. I want 50 quid if you're going to, if I've got to shave every day, mainly because of the health and safety in the face fit masks. And that's just some of the problems that come across. So what have we been doing? This is something that I kind of talked to because it gives you a better idea of the type of stuff we do for clients. And so far this month we've claimed over 30k of funding for our clients. So we put cash into the banks, and hopefully there'll be another 25k towards the end of this week, which all comes through the CITB, and I think I'm underestimating those numbers because I don't know how many you've got. And both of them, so that takes up to another 15k on top of 25, so it's another 40k. So we've also helped the clients by should they claim for all the training activities. I've been trying to work out the CITB online training thing this week, and it is impossible. But we've stuck with it, and we're making progress. We've helped some of them find apprentices. About it's 4 this month. 2 for a plasterer, 1 for a painter, 1 for a roofer. We've developed more performance management processes to help them, especially with their apprentices, to make sure the apprentices are making progress against the NVQ. And it's all around attitude and behaviours rather than the skills. We've put processes in place, as we always do, to ensure they get paid for what they do, extras and variations. We've helped them manage their site staff to train them to do site audits. We've developed job forecasts. I'll come back to this a bit later. One of the things we get all our clients to do is a job that's a forecast, because it shows you what's coming up, when you should be invoicing for it, who's going to do it. It's a one-size-fits-all tool, pretty simple, and it's on the members area of the site if you join, so you can join it and have one. We also do things around LinkedIn and Twitter and Instagram, and Jamie does a lot with Hootsuite with clients to kind of manage their social media stuff. And we've got them improved opportunities through Dale and his LinkedIn helper and his lead generation stuff. And even now we're looking at other funding streams. I'm doing some work with one client to help set up an academy where we can draw down funding to help him train his own staff and other people's. So it's loads of stuff that we do. So, what do you get as a member? You get access to all the groups. Currently Sheffield and Leeds. We've got a few more planned in the new year. And you get, as I said, videos of all the presentations, so you can go back and look at what Laura said in 3 months' time and think I need to speak to her because I've got an issue, or 13 months' time, or 3 years' time, or whatever. There's some free stuff, like I've said. There's job forecasts, there's site audits, there's everything in there that can help you to organise your business better. There's a jobs board, and you get access to experts at reduced rates, and it's annual payment, it's a one-off, 400 quid, or there's a monthly direct debit if you fancy doing that. So I'm going to hand you over to Laura.
Thank you. Well, good afternoon, everyone. Welcome to my seminar of dispute resolution. I've put quite a few slides on. There's about 30 in total, but I will hopefully just whiz through them. And if you have any questions, just feel free to ask me along the way, because if you're anything like me, by the time you get to the end of the presentation, you'll have forgotten what questions you had. So just feel free to pop your hand up and ask away. So a little bit about me. I'm a commercial litigation solicitor. I've been litigating for 6 years, nearly 7, it'll be 7 in February. And I qualified 3 years, it'll be 3 years in April. So I was working as a paralegal, got all my experience in litigation, thought I'd really enjoy this. Not just the litigation side of matters, more the dispute resolution, because essentially litigation is always a last resort. There are lots of different types of litigation, which I'll be coming on to. But essentially, you need to make sure that, what I always say is, if you get it wrong at the start, it all falls apart. So I say that probably 5 times a day. And it's really key to make sure that your contracts are all inclusive and they cover you and they afford you the protection that you really need. So Oakwood Solicitors, who are we? Full service law firm. Obviously got commercial litigation and dispute resolution, which is what I do. We've got an employment department for anybody that you know that may benefit from employment advice. Conveyancing, residential and commercial, wills and probate, personal injury and debt recovery. Our debt recovery team tend to run debt claims up to a certain point, and then if it gets any more complex, it tends to come to me. If it's not a straightforward matter, but anything to do with commercial dispute and resolution, it'll come to me. So the agenda for today, we've got common scenarios, anything that sounds familiar to you. The idea really is anything that rings a bell and you think, yeah, I know somebody who that applies to, or that definitely applies to me. What do you do when faced with a dispute? The different processes, what you need to know. Case studies, just a few examples of the things that I've come across in the past and currently have ongoing, and how we can help you and your business. So who do we help? Businesses of all size, predominantly SMEs, much like Grant was saying, it's the smaller companies who tend to come to us. We're based in North Leeds, Oakwood, and we have about 100 employees, so we always tend to market at the SMEs as opposed to the big sort of Balfour Beatty's and the big companies that might want a firm of solicitors who's a little bit bigger. We can deal with people or clients on retainer. I have clients who come back to me on a weekly basis. Once we put one fire out, another one starts. And that tends to be because they haven't got the bits and bobs in order at the beginning. So it's kind of that domino effect into bigger problems. And clients not on retainer, they can come to me fixed fee or on an hourly rate basis. It's entirely up to them. So, any of these situations sound familiar? Not being paid at all, not being paid enough, problems during construction, fallout post-completion, breakdown in communication, walking off-site, being asked to remedy problems, issues with subcontractors, issues with suppliers, and timescale issues. Now, any of those sound familiar? Yeah, I thought they might. So I mean, these are the kind of problems that I see on a daily, weekly basis. And the more we work through these slides, the more it'll become apparent what you can do, and also what you do when you find yourself in that situation and how to prevent that situation from occurring. But these are the kind of issues that I tend to deal with. So what do you do when faced with a problem? Well, you can try and resolve it yourself, make things worse by accident, ignore it, throw money at it. Now, I tend to see most people try and resolve it themselves because they think, right, this is a big problem for me. I'm going to tackle it head on. I'm going to go in, I'm going to be aggressive, and they make it a lot worse because the other side are hostile, they're not cooperative, and it's more, it entirely depends on the situation, but you can tailor the way that you deal with these kind of disputes depending on what it is that exactly has happened. So I tend to see that people try and resolve it themselves, then they ignore it because they've really messed it up. So they ignore it for a few weeks, if not months. Then they accidentally make things worse by ignoring it, and then they have to throw money at me to try and fix it. Whereas what they should have done in the first place, before they even had a dispute, was come to me, get your paperwork, get all your ducks in a row before you enter into these big kind of contracts with your clients and move things forward. So the moral of that story really is that if you don't get your ducks in a row at the beginning, it is going to be expensive, and a lot of people think they see solicitors as expensive because we are, but it doesn't have to be if you try and get things right at the start, basically. So the evolution of dispute resolution. All these 5 processes tend to sound the same. So when I say them out loud, I've got adjudication, expert determination, litigation, mediation, arbitration. And I wouldn't be surprised if in the next sort of half an hour or whenever this presentation finishes, you think, now I can't remember which was which, why it's different, they all sound the same, they all end in shun. So I'm just going to pick up the phone to Laura whenever I have some kind of dispute and ask which one of these is actually relevant to me. Now, which one's relevant will normally be dictated by your contract. Now, it's not unusual to not have a contract. And I mean, anybody in business will know that a contract is very important. And I'm not going to teach you how to suck eggs, but a lot of the time you have good relationships with people. You often strike up a relationship with somebody and you think, right, yeah, I'll do this job for you, this, that, the other. It all falls apart, it all goes wrong. And then you think, I haven't got a contract. And sometimes I wince because I ask the question knowing full well they're going to say, oh, I've got something written down somewhere, I think we exchanged an email, but nothing formal. Now that's fine, that's not a problem. If we've got enough emails to almost cobble together a contract, you've got offer and acceptance, you know what you're supposed to be doing. But if you've got it written down in a signed agreement, you've sat down, whether that be with solicitors or just by yourselves, you're affording yourself a lot more protection than you would be without it. So we're going to run through these different processes. and if you have any questions along the way, by all means do just ask me. I've put the benefits of each process on the slide, and then I will be talking about the negatives. So if you want me to repeat anything, then just let me know. I've already spoken about the contract. So what is adjudication? Neutral third party decides. So that's, obviously you imagine litigation to be with a judge, and everybody pictures this big judge in this big courtroom, and it's, you know, it's filled with arguing parties on either side, but it's actually not always like that. You've got the pay first, argue later. I know that I was speaking to Tim earlier about the cash flow issues. We've touched on that briefly, and how cash flow, if you don't get paid for a few months, then that could be your business done. And that's something that's worth considering with adjudication. Decision of adjudicator will be binding unless revised in arbitration or litigation. So it's not necessarily, once you've got the decision of the adjudicator, if you disagree with it, you have the option of going to arbitration or litigation. So it's not necessarily the end of it. But anybody who's thrown money at adjudication by this point has more money than sense to be appealing it. I have seen it happen, but it's normally decided one way or the other, and the adjudicator will be appointed from the Technology and Construction Court. Just going to have a look for my negatives. Yeah, so the disadvantages, we've got the dispute needs to have been aired between the parties before adjudication can be commenced. So I wouldn't ever, if a client came to me and said, I want to adjudicate this matter, my contract says I have to follow adjudication, I don't know what it is, but I'm guessing you do, will you do it for me? I'd need to know the background as to where this had come from, how much they'd discussed it, because the adjudicator's expecting you to have at least tried to resolve it before you get to him or her. And the adjudicator's powers are limited, and court proceedings are still required to enforce the adjudicator's decision if the losing party doesn't pay, which is what I touched on earlier. And those are the benefits: the neutral, quick, cash flow maintained, less expensive than court proceedings, which is what a lot of people ask: is what's my cheapest option? What's the quickest and cheapest? I mean, it's not. A lot of people call adjudication rough justice because it's, although it is quick, and when you've served that notice to adjudicate, you've pushed that snowball down the hill really. And it rolls, and it is relatively quick, but because it's quicker, it's less expensive than litigation, but that doesn't by any means mean it's cheap. Expert determination, again, you've got, I mean, it is what it says. It's an expert determining whether or not your claim falls with the claimant or with the defendant. It's essentially a valuation of the dispute, because a lot of the time evaluation can be key. So you're saying, well, I think we should be paid 20 grand, and the defendant's saying, well, I'm only willing to offer you 5 because you've only done 5 grand's worth of work, that kind of thing. You put it to an expert. You've obviously got issues with getting your own expert in the first place, because even though it's going to expert determination, you may want to get your own expert evidence, because essentially the expert's going to need something to decide other than just his own opinion. But that's the same with any of these processes. Experts are key.
Do you have to be a trained arbiter to be an expert?
For expert determination, I'm not entirely sure if you have to be a trained arbitrator, no. There will be certain qualifications that they need, but whether or not that's the same level as an arbitrator, I'm not entirely sure, but I can find out.
And do they need to be commercially minded people as well, because they're making commercial judgments? As they
essentially they
are.
An
expert commercial firm, I presume.
There's somebody that does that, and his background as a QS estimator.
So their background will have been within the industry, So that's where it's not Joe Bloggs, but it can be one of the benefits to expert determination by using expert determination, because you've got somebody you're not putting it in front of a judge who normally deals with straightforward debt claims, who's saying, what's all this evidence? I don't know what hempcrete is. I don't know what these different terminologies are, which, I mean, a judge would never say, but I'm presuming they often do think.
I know I've got colleagues who've done the training, but they're have commercial background, so I'd kind of work out what they do really.
Yeah.
So.
And the benefits of economic, you've got a final resolution, that decision of the expert is final. It's less expensive because the experts, although they are expensive, they're less expensive than long-winded litigation. And it's a bit less formal, so it can be a bit less intimidating compared to any of the other processes.
Quicker or longer than adjudication?
I'd say on a par with. It's not. Yeah, I'd say on a par with, but then it kind of depends how busy that expert is as well.
Because an adjudicator decision, he's got a set time limit to actually make a decision.
Yeah. Mediation then. So we've got. I see a lot of mediations, particularly because the court is encouraging mediation to happen. Now, if I were to go to court, and I must say this to my clients 5 times a week, when they say, I don't want to mediate, we've fallen out, and I don't think we're going to get any sense out of them, so what's the point? Well, there was one particular situation that I had where my client was absolutely adamant he did not want to go to mediation. He obviously instructed us to act for him, and he was a big property developer, and the defendant had instructed a big firm in Leeds, and we ended up going they were instructed in Bristol, so we had a mediation in London, and we went into the mediation room. The mediator who we'd instructed was obviously very familiar with the papers as much as they can be. They only allocate probably about a week to read through things. But they're just as busy as we are. And we made our submissions. The first offer from the defendant was £20,000, and we had we'd put forward an offer. We were at 1.2 mil basically. So we're sat in 2 rooms. One's at 20k, one's at 1.2 mil, and then you think it is going to be a very long day. But it's fine. It's fine that it's a long day. We got there at 9, left at 8:30, 9, catch the last train from King's Cross. But you want to make sure that if you've got people in the mood to negotiate on that day, mediation can be a really great way of resolving things. And you'd be surprised how much people come down and people come up, because obviously your first offers are never the offers that you think you're going to settle at. So the idea is you meet in the middle. But we certainly didn't meet at 500,000. But we did get it settled in the end. So we've got the fact that the court encourages parties to mediate. The only time I wouldn't, I say don't mediate if you really don't want to, is probably when it's the claims on the small claims track, which is probably irrelevant for today's purposes. But if in doubt, just mediate. And if it doesn't come to anything, then you haven't really lost that much apart from the expense, but at least you've tried. And especially when it comes to a point of costs, you really need to have been cooperative in all aspects. And you'd obviously be following the pre-action protocol for construction and engineering disputes. Yeah. Litigation, obviously we've got the benefits of mediation. Independent person facilitating discussion between the parties, highly experienced and rigorous in their approach to addressing the issues, looking at the strengths and weaknesses of both parties, helps maintain a business relationship. That's one key point actually, is helping to maintain a business relationship, because although you may have fallen out with people, they may still be really helpful for you. And it might be that if you can narrow enough of the issues, determine those and part ways amicably, it doesn't mean it has to be the end of the road. It's not all guns blazing, and a lot of the time a lot of the time you have a lot of respect for these companies if you have built up relationships with them. Not necessarily, if you haven't, then it's a little bit different. And if you've taken a bit of a risk on using their services, you kind of wish you hadn't, and you wouldn't go back to them. But yeah, it can be a good way of maintaining a business relationship, and the mediators are very good. Certainly the ones that I know.
I think that's a really good point, Laura, because a lot of the companies we deal with are nervous of going down this route because, well, I might never work for them again.
Yeah.
And it's because, you're having a discussion with them.
That's it.
Do you know what I mean? And I think that's a really good point, that it doesn't have to be the end of the road.
No.
And it might change the relationship actually for the better.
Yeah, and I think if any of the processes are suited to that, I think it is mediation. I think it is a lot softer. And you're airing your thoughts and what you think, and then it's whether or not you can agree or not agree and meet in the middle. And if you really can't agree, then you've always got the option to move on to litigation. But a lot of the time you can get these things settled with a good mediator and with a good solicitor. Remains confidential, so anything said, I mean, there's nothing to stop the other, say mediation fails and you move on to the next stages. There's nothing to stop you bearing in mind, although they did say this and they did say that. When we say it's confidential, it would never be put before a judge. So it's human nature, isn't it, to think, well, didn't they concede that point, or didn't they suggest that there'd be room for manoeuvre on that? You can bear it in mind, but it certainly wouldn't form your statements of case unless you wanted to serve a notice to admit fact, which is completely different and we won't get into today. What is litigation? We've obviously got court proceedings, claim worth over 250,000, you'd be using the Technology and Construction Court with a specialist Technology and Construction Court judge. This is kind of key because I've seen it before where judges get bamboozled with information. And it doesn't matter, it's not just in relation to construction disputes, but in relation to any dispute. And because I deal with commercial litigation, it tends to be general. And the amount of times I've had judges look at me blank-faced and think, but what you've just said, Ms. Walton, makes no sense. And obviously it makes sense to me, it makes sense to my client, but the judge isn't necessarily dealing with these kind of claims all day, every day. So when you've got a dedicated TCC judge, it can really help the process move a lot quicker, and their understanding is a lot better, and it's a lot fairer for both parties. But like I say, the claim does have to be over 250,000 to get that dedication from a judge. But yeah, whenever I've dealt with judges in the High Court in London, whenever I've had a dedicated judge, it has been a lot easier. In fact, you can write directly to that judge, especially if the other side aren't behaving, and then they aren't happy about it. Yeah, complex issues can be dealt with, and then the county court appears to be one of the most expensive options because it can be quite long, drawn out. You've got your issue fee, which any claim over 200,000 is a flat fee of £10,000 to issue, and that's in relation to any claims, not specifically construction. Otherwise, it's 5% of the value of the claim. So you'll find that I might receive a letter of claim or an offer to settle, and they'll be looking at 50 grand, and then they'll issue proceedings for 10 because they don't want to pay the court fee. They essentially can't put the money where the mouth is, but that's entirely an issue for them. So that's litigation in a nutshell. It's longer, it's more expensive, but it's common. Arbitration is an alternative to litigation, referred to a third party. Material facts, documents and relevant principles of law are all considered. So the arbitrator will only consider what's put in front of him. So you've got all these papers, or the arbitrator's got all these papers in front of him, and he will make a decision based on those papers and nothing but those papers, essentially. The one big downside to arbitration is the cost. I was reviewing some arbitration papers. One of my clients had come to me and said, I want to appeal an arbitration decision. He'd unfortunately decided to arbitrate himself, and came to me a little bit too late, but he's considering appealing the arbitration, or the arbitrator's decision. In fact, he has already appealed it. I'm reviewing it to see what exactly went wrong and what he probably should have done 4 weeks ago when he should have come to me in the first place. But the cost of the arbitration was £9,500, and that was in Leeds, and then you've got the venue hire on top of that. And the two parties both equally bear their costs, so split in half. And that's the same goes for, say, when you've got a mediation and you've got venue hire, you're splitting the cost there, you're splitting the cost of the mediator. Depending on which mediator you have or which arbitrator you have, the costs will vary, but it is expensive. And that's why you've got to weigh up how much you're pursuing as well as how much you're going to pay to pursue it. Because ultimately, if you're not any better off, you'll just go through all the stress and then think, well, what was the point? Benefits of arbitration: you're confidential, the arbitrator will have relevant experience, relatively quick process compared to court proceedings, and the cost can be similar to litigation, although the process is quicker. Every business is different, and so is every dispute. So even the construction claims that I deal with, although the issues might be similar, there's always different parts to it. So it's really making sure what works for your business, and what's going to be the most effective remedy for you. Case study then. We've got ABC Company. You're a domestic and commercial electrical service. You've contracted with an existing client of whom is very happy with your standard of work. So you've dealt with them quite a few times, and you're their go-to people. You subsequently contract with another party, XYZ Company, to provide services to your client that you're unable to. You accept their price, raise a purchase order for the agreed sum, and the client changes a few elements of the original scope of works, nothing major, for which an additional purchase order was needed to cover all of the additional works. The works are agreed, however, XYZ Company does not deliver on one small part of the agreed works. You email them, you remind them, you ask why this one small part of the agreed works has not been completed, and you do not receive a response. What do you do? So I'd throw that open to you. Anything off the top of your head, what would you do? If somebody's basically fallen off the face of the earth, they've raised the purchase orders, they've been paid, what do you do?
On contract law, you're obliged, if there's a breach of contract, to bring another party in.
Yeah. So, unless you've got, although it's contract law, and also common sense would suggest, well, if this guy isn't going to do it, I will get somebody who will, and I'm of the understanding that I have paid XYZ Company such and such amount for all of the works. He hasn't completed this part, so I either write it off or I write to him and I pursue him. But what actually happened in this scenario is that the XYZ Company served a claim form on ABC Company with no demands for payment, no letter of claim, and that's when ABC Company came to me and said, I've got this claim form, there's absolutely no way I'm settling it, he wants about 1,500 quid. As far as I'm concerned, I've paid him everything, he didn't do what he was supposed to do, so I want to fight it. Now when you're dealing with a claim of £1,500 and you're litigating it, what the claimant is wanting, so what XYZ Company is wanting, is them to think, do you know what, I'm going to spend more money fighting this than I am to just pay him, so I'll just pay him. 7 months had passed and they've not heard anything from him. So I can completely understand why my client is frustrated that this has happened. But obviously relations have broken down. They've already got somebody else to do the work, understandably, exactly like you said. But but it's now a litigated matter. So when I spoke to them this week, they said, well, I've been forced to defend this claim because I'm not paying it, one, out of principle, and two, because if anything, he owes me money. Which is then when you kind of move into counterclaim territory, should he be counterclaiming for the amount of money that was sectioned off for that part of work. But it's kind of a typical scenario of small amount and with people just trying it on, basically, because that's what they think has happened. So that's I'll just give you that as an example just to get you thinking about what would you do. If we're looking on a bigger scale, this is not the same ABC and XYZ, this is a different example. So you're a specialist in building and constructing barns. Your project value is for 1.2 million for 2 barns. You contract with a civil and structural design service who put a programme together that you're happy with. The total cost based on an indicative design from XYZ company are initially estimated in the region of £880,000, and the total additional costs incurred as a result of XYZ company are £250,000. This is because the extra temporary works are required, construction was substantially heavier than in initial indications, late supply of drawings, no time to negotiate with suppliers against day rates rather than a contract price, stopping activities on site and cancelling concrete pours, timber panel drawings are wrong, brackets wouldn't fit, extra work on and off site, penalty from your client for late completion. What do you do?
Call you up.
That's the right answer, I like that answer.
But each of them is a claim. Each of them have got their own. It's not one thing, it's several things, and you need to break it down.
Exactly, break it down, yeah.
So I've got a colleague who lives just up the hill up in Grenoside. He does supports dispute resolution from a programme perspective. So he the chap called Mark Mosley, he does a plan, works out how long it would have taken if everything was fine. So any additional prelims on site, you can work out what the consequence was for each event, because that's one of the problems, is which event caused the problem.
Yeah, absolutely, yeah.
So he has to break it down and say, well, because you were late with the pause, or because you didn't give the drawings, that's the consequence.
Yeah.
Is that right?
Yeah, absolutely, and it's what flows from that action, what loss has flown from that action and what's caused it. If you throw into the mix the fact that you've got a quantity surveyor, you've got a site manager, you've got an architect into that scenario, does it change your opinion at all? Because I thought exactly the same as you when it first came through to me, and then when I looked, and I looked over the contract, and I thought there's so many parties involved here, which is often the case.
And in some cases, the parties have a side to pick, because the site manager is no way going to take any responsibility that it was wrong. They're going to pass it on to subcontractor.
Yeah.
And what I find is it comes down to he said, she said.
Yeah, absolutely, and they just all point the finger, and
they all point the finger at each other.
Yeah,
and it becomes a mess.
and it's like a cutthroat defence, really, because it's like, well, it wasn't me, or it was somebody else's fault. And then with the architect, and I mean, if the architect had overall responsibility for this situation, you'd really be thinking, although it's within a construction dispute, you'd also be thinking, what about professional negligence? Because if you're looking at the construction was substantially heavier than in initial indications, late supply of drawings, no time to negotiate with suppliers, stopping activities, it's all the different people all doing different things. And obviously the value involved is big, and it's a lot of money. So there's lots of different types of, or lots of different ways and lots of different angles that you need to be thinking about these kind of things. But I mean, that's my job. It's not, I don't expect you to know.
Yeah, I find that example kind of more the norm.
Yeah.
Do you know what I mean?
Yeah.
That's what happens,
absolutely,
and so much of it doesn't go to dispute.
Yeah.
Because that's just simply accepts that that's the way construction works.
Yeah.
I get frustrated because I know that all this stuff kicks off. And when they come to working out the money, they just do it on a handshake.
Yeah.
And you just think,
Yeah.
well, hold on, I've done all that
Yeah.
work to know exactly what happened, how much it cost, who was responsible. And it doesn't really matter because someone will just go,
Yeah.
oh, there you go, anyway.
That's it. And
Yeah.
there's no purchase order. There's normally no contract. There's normally an email saying, yeah, just get on with it.
Yeah.
There's an email from them saying that's how much I'm going to do it for, with no detail.
Yeah. Well, this is it. The amount of times I receive instructions, I receive paperwork, and I'm reading through it, and I think, so if that was the initial, if that was the situation at the outset, why has it changed so much? And then I ring them, and they say, oh, well, we varied that, and we varied this,
Yeah.
and I'm like, where's that written down? Oh, well, we didn't write it down. We just talked about it, and then, you know, it's difficult. But at the same time, if you've got your paperwork and you've got your contract and you've got a variation clause in your contract to say we can verbally agree, but it will be followed up in. It's not necessarily that other people or people will follow the contract or the letter, but at least you've got something in writing for when situations like this do happen. So it's really just thinking about you and your organisation and how, if you were faced with any of those scenarios, what you would do, or if you know anybody who's facing a situation, what you would do, and really looking at the contract. What does the contract say? If the contract is silent on how it's dealt with, it is often litigation that people choose to follow. I think they're a lot more familiar with the sound of litigation, not necessarily the steps or the process, but they think, oh, well, let's go to court. They don't think, oh, I need an arbitrator, you know. So it's, and a lot of the time people start claims on their own and then get themselves in a little bit of a pickle. So that's kind of recapping what I just said, but it's more, think about what could go wrong during your working relationships. Be proactive as opposed to reactive, and that's having your contracts. And if you didn't have a contract, we've got, like I was saying about the retainers and the non-retainers. If you want to come to me to draft your contract for 250, 300 quid, I can. It's not, it's the lesser of two evils when the absence of a contract will cost you 3, 4, 5 grand. So it's kind of putting the money and the brains behind it at the start as opposed to leaving things to chance. And seek legal advice before it's too late, and don't let disputes spiral out of control, because it comes back to that aggressive approach, ignore it, make things worse, and then have to pay me to fix it. So that's really what I wanted to help with. And then we've got, I have got some booklets and some notepads and stuff on the side with our packages. We've got bronze, silver, gold, all different prices, and that's on a retainer basis, so it would be a case of being able to pick up the phone anytime for anything. And then if your dispute didn't fit into one of our packages, then we just build bolt-ons and bespoke packages around it. So it's taking the fear out of ringing the solicitor and thinking, how much is this going to cost me? Because we are at Oakley Solicitors, we are a friendly bunch, and we are trying to be the go-to law firm, and we want to be approachable. So it's more a case of letting people know that it's not, it doesn't have to be as scary as it sounds, basically. Thank you.